Hello, I'm Kristy Steeves, and I'm here with attorney David Welty, who's authored a book of significant importance called Unfaithful Guardians. So, David, what made you feel compelled to write this book?
Well, Kristy, I wrote the book in part to counter what is taught in our schools and universities today, and has been for decades. Sadly, our students are not taught what the founders intended when they wrote and ratified the Constitution, or what some refer to as the original meaning. Instead, they're taught what the Supreme Court says the Constitution ought to mean, which is really quite different than the original meaning. The founders expected the court to understand and then apply the original meaning, and to do that regardless of the consequences. Thomas Jefferson wrote, on every question on construction, we're to take ourselves back to the time when the Constitution was adopted. And that's really the purpose of Unfaithful Guardians, to carry the reader back to the time when the Constitution was adopted, to discover and to understand the original meaning, and then to understand how the court has ignored that meaning and the consequences that have resulted.
Tell us about the title, Unfaithful Guardians.
Well, during the debates, while the Anti-Federalists were expressing alarms about the new proposed federal judiciary, Alexander Hamilton tried to calm their fears by explaining in Federalist Paper number 78 that the duty of the Supreme Court will be to serve as the faithful guardians of the Constitution. And what he meant by that was that the court was to guard the high walls that the Constitution had built around Congress and the President. Unfortunately, since the dawn of the 20th century, the court has refused to perform that duty, with the result being that both Congress and our presidents have breached those walls and are exercising powers that the states never gave to the federal government. Hence the title of the book, Unfaithful Guardians.
What's the central theme of your book?
Well, Kristy, the book is a book of history and the rule of law. The founders intended that the states would do most governing on domestic matters, not the federal government. James Madison, in Federalist Paper number 46, wrote that the first and the most natural attachment of the people will be to the governments of their respective states. The founders created the central government to be a servant of the states and their people, primarily for the purpose of national defense and for a unified foreign affairs, and to provide a few services on the national level, such as a postal system, a bankruptcy system, a patent law system. But the original meaning makes clear that the federal government was to be one of limited and explicit powers, thus permitting the people of each state to be able to self-govern with no federal interference, and with each state having the power to make choices on a variety of domestic issues, which could be quite different than the choices made by the sister states.
What steps can we take to move the country back to the founders' design?
Well, I have two thoughts on that. First, we must remember that our Supreme Court justices are appointed by the President and confirmed by the Senate. The well-worn adage that elections have consequences is particularly applicable when it comes to Supreme Court justices. When we vote for a president, an important factor to keep in mind is whether the president will appoint justices who will seek out and apply the original meaning, regardless of the outcome. That's what the founders intended for our justices to do, and that's really what the rule of law demands. Second, the states have the power to amend the Constitution and can do so with little federal involvement. They can call for what's called an Article 5 convention and propose amendments. The amendment can be one of clarification, so that even the most liberal justice will have great difficulty ignoring the language. An amendment of clarification might be a balanced budget amendment, an amendment that clarifies the meaning of the Commerce Clause or the taxation power, or even one that clarifies the meaning of the 14th Amendment. Some conservatives oppose an Article 5 convention. They're fearful of what is known as a runaway convention, which I think can be handled through careful planning. But what's important is that we don't allow fear to prevent us from exercising that power that our founders gave us, if needed, to take back our Constitution and to rein in a federal government that's out of control.
Why should Americans read your book?
James Madison, the father of our Constitution, and Thomas Jefferson both believed that education of the people is probably the most important safeguard of their liberty. The problem is, as I noted, is that our schools and our universities are not teaching the original meaning. I wrote the book for those Americans, both adults and students, who have a desire to understand the original meaning and have a desire to understand the founders' design for our nation, which is one of states that have practically unlimited power to govern and a central government that has limited powers, primarily devoted to national defense and to foreign affairs. We'll never take the steps that are needed to take back our Constitution until we have a critical mass of Americans who understand the original meaning, who have a desire to be governed by our founders' Constitution, and not by the Constitution that our Supreme Court has invented and is known by the euphemism of a living Constitution.
Is this just something that's just kind of evolved over the years to what it is today?
Well, it's become increasingly worse, really, in the 20th century. That the Supreme Court really has done two things. It's failed its duty as far as keeping in check Congress and our president from exercising powers that they really don't have. And what's happened is the court has turned its attention upon the states and has prevented the states from enacting powers that were given to them by their people and that the Constitution and the founders intended the states to be able to exercise. And it involves a variety of things, prayer in public schools, regulation of pornography, burning the American flag, issues of abortion or gay rights. These were all powers that each state was allowed to make decisions on its own, and it could be different from other states. The founders never intended for there to be a uniform standard on these things, and it was not the business of the federal government to be involved in those domestic issues. Those were all issues that states were to decide on a state-by-state basis. And the court has essentially suppressed state power, but allowed an expansion of federal power that was never intended.
How does this affect us as a society?
Well, I think fundamentally, what the founders intended and what is the greatest danger to our liberty is centralization of power. That's why they expected to have each one of the individual states really be an experiment in democracy. So, for example, one state may choose to have prayer in its public schools, another may choose otherwise. The same thing with abortion, for example. One state may choose to allow abortions, another may not think it's a good idea, and so on. And when each state can make those choices, and the people of each state can exercise their right of self-government, we're going to see the people vote with their feet and go to those states that have values that meet their needs and their desires.
Well, David, thank you for your time. A very important book on very important topics, Unfaithful Guardians.